Welcome all. In this session, we are going to discuss about company directors. First, we may discuss about who is director. Director is a person appointed to the board by the company. Who is board of directors? The term board of directors in relation to a company means collective body of directors. Okay. Next, position of director in a company. Director occupies the position of an agent. Director occupies the position of a trustee. Director occupies the position of fiduciary position. Regarding agent, we knew agent is a person who's acting in between two parties, that is the principal as well as the third party. Here, director assume the role of agent because he's bridging the gap between the principal, that is the company, as well as the public. Hence, he is known as agent. He is agent of the company alone, but not the shareholders. Okay, he is agent of the company, but not an agent of the shareholders. Trustee, he is acting as the position of trustee to some extent. Trustee has to manage or duty to take good care of the valuable properties vested in his hands. Hence, he occupies the position of a trustee. Fiduciary position, duty to take good care of the properties, powers, and manage funds. Okay, so he's managing the funds of the company, he's vesting more powers in his hands. Thus, he has to play fiduciary role. I hope you can understand. Next case, deemed director. He is also termed as shadow director or deemed director is a person on whose instructions or directions the company accustomed to act. Types of directors. There are two types of directors, full-time director and part-time director. From the name itself, we can understand full-time director is a person who appointed as full-time and whose livelihood position is depends in this company. He is also termed as executive director, managing director, whole-time director, or technical director. On the contrary, part-time director is termed as non-executive director. They are the professionals and their livelihood do not depend upon one company. They serve in many companies, large number of companies they can act. Next, women director. According to section 149 subsection 1 and 2 of Companies Act 2013, every company that is listed public company whose paid up capital is 100 crore or more or whose turnover is 300 crore or more must appoint at least one women director. And private companies are exempted from appointing women director even though their paid capital is exceeds 100 crore or whose turnover exceeds 300 crore or may not appoint women director since they are private companies. The minimum and maximum number of company directors is, in case of one person company they must appoint at least one director. In case of private company they must appoint two directors. In case of public company they must appoint three directors. And the maximum number is they may not exceed 15. If they want to exceed 15, they have to make special resolution passed. Next is resident director. Every company must have at least one resident director who has stayed in India at least 182 days in previous calendar year. They are termed as resident director. It is mandatory for both private as well as public companies. Independent director. In case of independent directors, every listed public company have at least one third of directors as independent directors who retire in rotation in the annual general meeting. Next, powers of board of directors. There are general powers and other powers. Regarding general powers, they have the power to make calls on shareholders in respect of money unpaid on shares. They have the authority to buy back their shares. They can have the power to issue debentures, borrow money, invest funds of the company, power to make loans. Other powers, they can fill up the casual vacancies, they can sign and sanction contract on behalf of the company, they can declare the rate of dividend of the company, they can appoint managing director of the company, they can invest in shares or debentures. On certain matters, they have to get approval of the shareholders. Say, for example, if they want to sell, lease, dispose any undertaking or asset of the company, or remit or giving time for repayment of any debt, or contributing to charitable trust, or borrowing money exceeds the aggregate of paid up value. For these cases, they have to get approval from the shareholders. Next, we will discuss about duties of board of directors. They have two roles to play as board of directors: statutory as well as general. Regarding statutory duties, they have to file returns of allotments in case of issue of securities. They have to disclose extent of interest in contract entered by them, not issue irredeemable preference shares, that is which exceeds 10 years or more, and they have to disclose receipt from transfer of property. Next, compensation received from transfer of any shares, duty to attend the board meeting, that is board meeting convened once in every 3 months, that is 4 times in a calendar year, they have to attend the board meeting. Next, they have to convene general body meeting, and they have to present balance sheet, profit and loss account, and any other essential reports they must present. And declarations of solvency position of a company while the winding up. These are all the statutory duties played by a board of directors. And there are general duties, that is duty to act with good faith. Next, duty not to delegate their duties or powers. Responsibilities of directors, they have to prepare strategic plans, operating plans as well as budget, monitor major capital expenditure which exceeds, that is long term financial plans. Next, they have to define and review board directions periodically. They have to set values, mission, vision of the company, and they have to check whether there are adequate resources available to achieve the company's objectives. They have to monitor and manage potential conflicts and make steps to resolve the same. At, at last, they have to govern the corporate governance must take care of by them. Okay. Next, appointment of directors can be done by articles of association, appointment of directors through company, appointment of directors through third parties, that is debenture holders, financial institutions, creditors, banks. Next, appointment of directors by board of directors. Next, by central government. At last, at proportional representation. Okay, so there are 6 headings: by articles of association, by company, by third parties, board of directors, central government, as well as proportional representation. The director can appoint uh, the casual vacancies or additional directors or alternate directors. In some cases, the central government may also appoint directors, but they do not have any qualification. The qualification is not mandatory to the director appointed by the central government. Next, we will discuss about removal of directors. Removal of directors can be done by shareholders, central government, as well as company law board. Removal of directors by shareholders. The best example is removal of director through Tata company. They removed a director named Cyrus. Removal of director by central government, section 388 subsection B to E speaks about whenever the central government may remove a director.